Welcome to the deep dive. Today we're taking the stack of sources you provided and we're going to zero in on one single, really compelling case. It's a case from the very earliest moments of Islamic legal history, but its impact, well, it continues to define family law all over the globe, even now.
And it's fascinating because it's so personal.
Right. Our focus today is on a single paternity dispute. It was highly emotional, legally very complex, and it happened in the very new community of Madinah 14 centuries ago.
And the resolution did so much more than just settle a fight between two men.
Exactly. It established a permanent legal philosophy. I mean, a foundational principle that was all about balancing this abstract, almost elusive idea of truth.
With the very real, non-negotiable needs of social dignity and, communal stability.
You really have to put yourself in that environment to get it. This was a time when the very concept of a state built on faith and justice was still being hammered out.
The stakes were incredibly high and very personal.
And there were no scientific tools. You have to remember this. No DNA tests, no blood typing, no complex forensics to verify who was telling the truth.
None. Justice had to rely entirely on testimony, on context, on logic, and on faith. The solution that the Prophet Muhammad provided in that moment became what we could really call a cornerstone of family law.
A cornerstone, I like that.
And that cornerstone is this powerful concept, a legal maxim known as al-wala lo firash.
Okay.
Literally, it translates to the child belongs to the bed.
The child belongs to the bed.
Yes.
Yeah.
And this is so much more than just some, historical relic. It's an incredibly sophisticated legal mechanism. It dictates how lineage, or nasab as it's called, is established, how it's protected, and how it's prioritized.
And it's a rule that's still relevant today.
It's fighting for relevance, especially now when advanced science seems to promise us a definitive answer for every single ambiguity. When we study ancient legal wisdom, especially a principle that addresses these universal human issues, like family integrity, the rights of children, we're doing something really necessary.
I mean, the fact that a single ruling from that time could survive. Think about it. It survived the early caliphates, the vast Abbasid Empire, the Ottomans, the Mughals.
And it still maintains its force in complex modern legal codes. You mentioned the sources, and they point to Section 128 of the Kanuni Shahadat in Pakistan. That's a direct echo. It just speaks to the profound, the inherent depth of its logic. It's a true legal axiom. And to understand it, we have to understand the crisis it was born from.
Okay, so let's do that. Let's unpack this. We have to set the scene properly to really feel the weight of this ruling.
Yeah.
We're in Medina, right?
Yeah.
Shortly after the Hijra. This wasn't some sprawling city with, centuries of established institutions. This was a community that was actively finding its footing. It was establishing its own social contract, its own legal order, basically from the ground up.
And it was extremely fragile. The whole community was held together by this shared faith and really the need for mutual protection.
And the people involved in this specific dispute, who were they?
They were two men from the local community, the Ansar.
So for our listeners, these are the helpers, right? The residents of Medina who gave refuge to the Muslims migrating from Mecca.
Precisely. They were the socioeconomic bedrock of this new state. So when a dispute erupts among the Ansar, among the foundational pillars of your society, it's not just two guys arguing over a piece of property.
No, it threatens the social contract itself.
Absolutely. And lineage, or nasab, at that time was. It was everything. It determined your inheritance, your identity, who you could marry, who was obligated to protect you in a fight, your entire standing in the community.
So to challenge someone's nasab was to challenge their whole world.
You're essentially trying to erase their identity.
And this conflict was severe. Both men were claiming paternity of the exact same newborn child.
It's fundamentally destabilizing. This isn't a dispute about something that might happen. It's a claim over an existing human being, a child. Each man insisted he was the biological and legal father.
And therefore had the sole right to that child's identity and future.
Yes.
We have to pause here because I just want to appreciate the enormous practical problem the prophet was facing.
It's immense.
He presented with two claimants. Both of them are probably sincere in their belief. And one child. How do you even begin to decide? The challenge of proof is absolute.
There are no scientific methods, no documentation besides what people say. This is pure arbitration, where the judge's wisdom and the weight of the legal framework have to substitute for any kind of empirical data.
And that's precisely why this case is so foundational, isn't it?
It is. It highlights the incredible difficulty of achieving justice when the empirical facts are just unavailable, or they're contested.
So justice, in this scenario, it has to be derived from something else.
From sound moral and communal logic. The prophet had to navigate a situation where raw testimony could easily conflict, and the decision, whatever it was, had to prioritize the welfare of the community and, most importantly, the innocent party.
The child.
Always the child.
So this brings us to the core question of the process itself. What stands out about his approach to arbitration here? I mean, the facts were so emotionally charged, they were scientifically unverifiable, and politically sensitive because of the Ansar involvement. How do you maintain authority and calm in that kind of tension?
Well, the key distinction that you see in the historical reports is the calm, systematic approach. This wasn't a rash judgment. It wasn't emotional.
Yeah.
He proceeded by calmly seeking context. He observed the statements of the two men, and importantly, he also observed the child's physical appearance.
Looking at the child. That's interesting.
Right, and that point is often noted because, in the absence of biology, physical similarity was the closest thing they had to objective data. Does the child look more like this man or that man?
But that's so subjective.
It's incredibly subjective and unreliable, and that's the key. Simply looking at the child and finding a resemblance was not enough. It couldn't be the basis of the law.
So the goal had to be bigger than that.
The goal of the arbitration had to transcend just a simple factual determination. The verdict had to reflect what the sources call divine justice balanced with human wisdom.
Divine justice balanced with human wisdom. Oh, break that down for me.
Well, divine justice might demand identifying the true biological father, whatever it takes. But human wisdom. Human wisdom demands stability, structure, and the protection of an established legal framework.
Ah, I see. That synthesis justice demanding truth, but wisdom demanding stability. That feels like the most potent part of this.
It is. The decision had to settle the dispute between the adults, sure, but the overwhelming primary priority was the child.
Any outcome that left that child's status uncertain or branded them with illegitimacy in a society where nasab was everything, that would have been a massive institutional failure.
A catastrophe for the child. They needed an immediate, stable identity, recognized rights, right now.
Yeah.
And think about the consequences. If you rule against the established bed, the marriage, just based on one man's claim, with no scientific proof, you introduce endless instability. You're essentially legitimizing every challenge to every family.
It would be chaos.
Total chaos. So the legal system had to choose the structure that minimized social damage and maximized the child's welfare, even if it meant prioritizing the legal framework over a potential biological fact. The whole process was designed to arrive at that protective, stabilizing synthesis.
Okay, so this measured approach, this synthesis of justice and wisdom, it all culminates in the famous ruling, the one that established the permanent legal standard for these kinds of disputes.
It's brief, it's decisive, and it is packed with legal weight.
And this is one of the most cited legal axioms in Islamic history, right? Without a doubt. The Prophet declared, "The child belongs to the owner of the bed, and for the adulterer is the stone." The child belongs to the owner of the bed, and for the adulterer is the stone. And you said this is codified.
Verified and codified in the most authentic collections of prophetic sayings. We're talking about Sahih al-Bukhari and Sahih Muslim. The fact that these foundational compilations transmit the exact same ruling gives it an unassailable status as a source of law. Okay, so let's dissect it, starting with the heart of it. That phrase you used earlier, al-walad lil-firash. Yes. So al-walad is the child. Simple enough. Al-firash literally means a mat, a carpet, a bed, the place where conjugal relations happen.
But it's not literally about the furniture.
No, not at all. Legally, it's a very sophisticated euphemism. It's a legal construct that references the valid, lawful marital contract. That contract is what establishes the mutual rights and obligations between a husband and wife, including the presumption that any offspring belong to the husband.
So the law accepts this, this legal fiction, the bed, to represent the state of a lawful marriage. It's not the physical sheet, it's the legal bond.
That is a crucial distinction. It has to be stressed. The law is defining a legal relationship, not trying to prove a physical act. The firash, the legal bed, is established the moment the marriage contract is validly entered into and consummation or even just the possibility of it exists. Once that legal bed is established, any child born within that time frame is automatically ascribed to the husband.
So the husband doesn't have the burden of proving he's the biological father.
None at all. It is assumed. It's the default legal reality, unless it's disproven by an extremely high legal standard.
Wow. That immediately places a massive burden of proof on anyone else, anyone trying to dispute the marriage's claim.
A huge burden. So let's analyze the second half of that statement. And for the adulterer is the stone. Now, that sounds harsh. What is its legal function in this context? It has a dual function. The first part, as we said, establishes the positive. Lineage belongs to the legal father. This second part establishes the negative.
Which is?
That the outsider, the adulterer, gains no legal status, no lineage, no rights to the child, even if he can somehow prove biological paternity. It's a complete legal disqualification. It's a total extinguishment of the outsider's claim.
So the stone isn't necessarily a literal punishment in this specific context.
The metaphor of the stone refers to rejection, to disappointment, to being completely shut out. In many historical interpretations, yes, it meant they gained nothing but the punishment, or at least the potential for punishment, for their illicit act. But in this legal context, it means their claim to the child is crushed. It's worthless.
It ensures that illicit relationships, even if they result in offspring, cannot legally disrupt the stability of a lawful marriage.
That's its entire purpose. Which leads us directly to the bedrock principle here. This immediate and inherent presumption of legitimacy. A child born within the boundaries of a lawful marital contract is legitimate. Full stop. Precisely. The child is legally linked to the husband, the owner of the bed, who has fulfilled his contractual obligation, and not to any outsider who might assert a mere biological claim. This is the law consciously prioritizing the contractual legal framework over unauthorized illicit claims.
And this is the aha moment. This is what links this ancient law to modern law for our listeners. This historical ruling operates identically to the modern legal concept you find in civil law systems all over the world.
The presumption of legitimacy.
The presumption of legitimacy. If you are born during a valid marriage, you are legally legitimate. And that presumption is so powerful that it requires extraordinary evidence to overturn it. We're seeing the historical philosophical precursor to a universal legal concept right here.
And to fully grasp the mechanism, you have to contrast it with the exception. There is a way out for the husband. It's called lien, the oath of condemnation. The Firash rule is so strong that only the husband himself can challenge it. An outsider can't. And he has to do it through this very specific, solemn legal process that involves mutual oaths before God. He's essentially swearing the child is not his.
And if he does that,
if he successfully completes the process of Lana, the marriage is dissolved and the child's nasab is stripped. But it is a destructive, high-stakes legal recourse. It's like a nuclear option. And its existence just shows how protected the basic Firash rule is.
and an outsider can't use this.
No, only the contractual partner, the husband, can dismantle the bed, and that is crucial for maintaining the boundary.
Understanding the verdict is one thing, but the truly profound insight here is the philosophy behind it, the ratio decidendi, the reason for the decision. Why did the prophet make this strategic choice? I mean, it clearly wasn't arbitrary. It was profoundly strategic in building a sustainable, just society.
Right. If we connect this to the bigger picture of societal architecture, you can see three primary aims, all interlinked, that really dictated this ruling.
Right.
The first and the most foundational aim was to protect family integrity. The rule stabilizes the marital unit. It places the family, defined by that legal contract, as the untouchable foundational structure of society.
Because if you allow any external biological claim to constantly challenge established families,
You strip the marriage contract of its power and stability. It becomes meaningless. The Firash rule ensures that the husband has legal certainty that his family won't be torn apart by outside claims.
okay, so that's the first aim. The second seems pretty obvious from that.
Preventing social chaos.
I mean, if you didn't have this rule, just imagine the logistical nightmare. Every single birth could be contested. Every father would have to somehow prove his paternity against any man who claimed intimacy with his wife.
Yeah,
Exactly. It would render the legal status of marriage essentially useless. The Firash rule draws an undeniable bright line. The marriage contract is the primary source of lineage. A legal system can't exist if it's constantly chasing shifting biological truths that could destabilize entire communities. This principle provides immediate legal certainty, and that is essential for social order. But let me play devil's advocate here. I'm thinking of the modern, maybe more individualistic listener who prioritizes the truth above all else. Isn't this system inherently unfair to the biological father who is shut out? Isn't it just protecting a cuckolded husband? I mean, isn't the law prioritizing a legal fiction over a verifiable biological fact?
That is the intellectual fiction point, and it's a necessary challenge. The way the ancient system prioritized this is, well, It's a conscious choice. When a legal system is built to serve the collective good, it sometimes must subordinate individual assertions.
So what does it say to that biological father? The law effectively says to the biological outsider, you chose to conduct your relationship outside the lawful contract. While you may have a biological claim, you forfeited your legal claim to lineage, to nasab, the moment you violated the sanctity of that marital bond. So the legal system is saying, what? Biological truth is important, but not the most important thing. It's saying that biological truth is important, but communal stability and the welfare of the innocent child are more important. The stability of the 1,000 homes in the community is given priority over the factual claim of one man who acted illicitly. It's a form of legal realism, achieving the maximum benefit for the maximum number of stable units. And this brings us to what feels like the most compelling aspect of it all, preserving the child's dignity.
Yes, the child is the innocent party in all of this. The law is designed to ensure that the child immediately receives an undisputed lineage, and that brings with it concrete, tangible rights.
Okay, so let's talk about those specific consequences.
Yeah.
When nasab is established by Firush, it's not just a name on a piece of paper.
Not at all. First, inheritance, or mirath. The child gains immediate, protected rights to inherit from the father and the father's family. Without nasab, that child is legally stateless in terms of family wealth.
Okay, so inheritance, what else?
Guardianship, or wilaya. The father gains legal guardianship. He's responsible for the child's education, their marriage, especially for females in that context, and their overall welfare.
And there's a social component too, right?
A huge one, mahram relationships. This is essential for social integration. Establishing nasab confirms who the child cannot legally marry, the marriage prohibitions. Who is your brother, your aunt, your uncle? Without a clear lineage, the social fabric just breaks down.
So the Farish rule ensures the child is not left in this horrible limbo while the adults argue over biology.
Exactly. The child's identity and future are secured immediately by the legal contract, regardless of any private biological facts that might exist.
So the crucial distinction here, the thing we keep coming back to, is biological fact versus legal status. The principal deliberately chooses legal and social status over potential biological claims from outside the marriage. The law is creating a strong, almost impenetrable legal reality to protect the most vulnerable party.
And the source material, particularly the insights from Mr. Zahir Ahmad Mir's research, makes this moral connection very clear. Justice in Islam is not only about proving facts. It is fundamentally about protecting honor, family, and the innocent.
So a biological fact, no matter how true, can't be used to destroy the honor and the stable life of an innocent person.
Especially a child whose entire destiny is dictated by their legal standing.
The well-informed insight, then, is that this rule acts as a high legal barrier. If you want to disrupt an established lineage, you need clear and convincing evidence that meets those specific legal standards we talked about, like the live-in, not just a suggestion of a biological link.
The burden of proof is placed heavily, almost entirely, on the outsider who is seeking to dismantle the marital claim. It's a legal jurisprudence rooted in sociological necessity. It posits that an imperfect but stable legal framework is infinitely superior to a biologically accurate but perpetually unstable society.
It's a choice for order.
Yes, it's a choice for order and protection.
The journey from that 7th century ruling in Medina to today is just. It's astonishing. This precedent didn't just survive, it became the undisputed cornerstone of fiqh al-usra, or Islamic personal law.
Which governs family matters across the Muslim world.
And its universality is what makes it so powerful. This isn't some minority view.
Yeah.
Not at all. It was adopted by all the major schools of Islamic jurisprudence, the Hanafi, the Maliki, the Shafi'i, and the Hanbali schools.
All of them. All of them. Now, they might have differed on the specifics of its application.
Like what?
Well, for example, the Hanafi school's rules regarding the minimum and maximum gestation periods, they define precisely when a child is legally covered by the fiyash.
To determine if it was plausible.
Exactly. They set rules about the minimum 6-month gestation period after a marriage and the maximum period after a divorce, the iddah, which in some Maliki interpretations could stretch up to 4 or 5 years. These were all attempts to define the physical boundaries of the legal firash. They were trying to logically determine if the child could plausibly belong to the bed, thereby reinforcing that initial presumption. But they all agreed on the core principle.
The legal bed is the source of lineage.
Yes.
And this influence isn't just confined to, religious courts. We see its logic codified in modern national law. blending this tradition with secular legal requirements across very diverse nation-states.
Mm-hmm.
One specific detail our sources highlight is Section 128 of Pakistan's Kanuni Shahadat Order of 1984.
Right, a modern evidence law.
And the statute, which governs evidence in Pakistani courts, directly incorporates the spirit of al-walad lil-firash. It essentially states that a child born during a valid marriage or within the specified number of days after it's dissolved is considered conclusive proof of legitimacy.
That's the ancient principle translated directly into modern evidentiary rules. And you see similar codifications all over the Muslim world, from Egyptian family codes to statutes in Indonesia. They all provide this powerful presumption to protect the child's nasab.
It shows how this ancient wisdom is still legally and politically active. It's adapting to, but not being overwhelmed by, modern legislative structures.
It's incredibly resilient.
Okay, so now, here is the modern paradox. This is where the conversation gets truly challenging. How does this ancient rule, which was founded on the lack of empirical evidence, hold up when DNA testing can offer a definitive biological truth with near 100% accuracy?
This is the great legal, ethical battleground of contemporary family law. It really is. And the stance adopted by most jurisdictions that are influenced by FIRA is, well, it's complex.
They don't just throw the old rule out.
No, they acknowledge the accuracy of DNA, of course, but they often restrict its admissibility in court, specifically when it's being used by an outsider to try and dismantle an existing, stable, legal lineage.
So the principle is still cited?
Explicitly. It's cited to balance biological truth with social justice. Okay, so the law is essentially saying DNA proves a biological fact. But the Firish rule establishes a legal status that must be protected. The legal system subordinates the scientific data to the higher principles of legal stability and human dignity.
So if a husband accepts the child and the Firish is established, the courts might just reject DNA evidence brought by an outsider.
They often will, precisely because the consequences of overturning that established nasab, the loss of inheritance, the social stigma for the child, the destruction of their identity, are deemed too severe.
That highlights a genuine fear of technology, doesn't it?
Yeah.
An implication that modern science, while it's accurate, has to be managed carefully so that it never destroys human dignity or lawful lineage.
That's the core fear. If we allow cheap, easy DNA testing to become the default mechanism for challenging every single marriage,
All that stability is just gone.
it's gone.
So let me get this straight. A man is legally recognized as the father through Firash. An outsider comes along with DNA proof that they are the biological father. Are you suggesting the court might actually prioritize the husband's legal claim simply because tearing down the legal structure hurts the child more than upholding the biological truth helps the outsider?
In many jurisdictions influenced by this principle, yes, absolutely. The legal truth is prioritized. The child has an established identity, established rights, a sense of belonging under the Firash. To overturn that established nasab based on a genetic test, especially one requested by an outsider who has no legal obligations to that child, is seen as an act of profound injustice against the child.
The law protects the child's established dignity over the biological assertion of the third party.
Yes. And for the listener, the key takeaway is that this principle reinforces the idea that legal truth is sometimes necessarily more about societal protection and stable identity than it is about purely scientific data.
The law isn't just built to catalog facts.
No, it's built to manage human relationships and consequences. And when facts lead to profound social disorder and harm the innocent, the legal system, guided by al-Walad lil-Firash, holds the line. It demands stability first, and it requires extraordinary legal recourse, far beyond a simple genetic test, to overturn that stability. So, to synthesize our whole journey here, we started with a tense, fundamental paternity dispute in the formative years of Madinah. That single pivotal event led to the establishment of al-Walad lil-Firash. The child belongs to the legal marriage, the bed.
Right. And today, that same concept functions as this powerful, enduring global legal principle of the presumption of legitimacy. The central nugget, the thing to take away, is the power of a legal principle that makes a conscious choice. It chooses to prioritize the protection of the innocent child and the integrity of the family unit, the cornerstone of society,
over the potential disruptive, destabilizing claims of outsiders, even those backed by biological fact.
It's a profound, effective act of social and legal design.
And the relevance to you, the listener, is in understanding how all functional legal systems, whether they're ancient or modern, are designed not just to render judgment. They're designed to fundamentally stabilize society and grant dignity to its members.
The law steps in to ensure that the child isn't left in this legal, social, or economic limbo because of adult controversies. It prioritizes their stable identity above all else.
Right. So, finally, let's leave you with this provocative thought. It stems from the assertion that knowledge is most valuable when understood and applied.
Okay.
If the historical purpose of this justice system was fundamentally to protect the honor and the established lineage of the innocent child, we have to constantly ask ourselves, even as genetic technology advances, in modern family law disputes, particularly those involving DNA evidence where there's an established nasab, are we sufficiently prioritizing the dignity and the stable legal framework of the child over the immediate demands of biological data?
A tough question.
It is. What are the practical, the ethical, and the legal limits we must place on biological truth when it attempts to disrupt a stable, legally recognized family structure? That foundational choice stability over mere fact is one worth mulling over long after this deep dive ends.